This video will cover what is a constitution, why we must change the constitution, what changes are required, when must we make changes to the constitution, what the legal process is for making changes to the constitution, and how to get more information before the AGM. What is a constitution? Every incorporated association needs to have a set of rules that describes the organisation's basic structure and processes and outlines the rules that it operates by. For Access Plus WA Deaf, this is called a constitution. The constitution is a written document which will usually specify the aims or objects of the organisation, how to become a member of the organisation, the rights and obligations of members, how the office bearers and members of the governing body are elected or appointed, how general meetings of members and meetings of the governing body are convened and conducted, how the organisation is, in broad terms, to be governed, and what will happen to the organisation's assets if it is wound up. Why we must change the constitution. In Western Australia, there was a change in the law, and all associations that were incorporated under the Associations Incorporation Act 1987 are now incorporated under the new Associations Incorporation Act 2015. Each association must review and update its constitution to ensure the rules comply with the requirements of the next law. Access Plus WA Deaf is the trading name of the WA Deaf Society Incorporation. As an incorporated association, Access Plus WA Deaf must follow the new Associations Incorporation Act 2015. It is important that our constitution accurately reflect how the organisation is governed and are up to date with any changes to the law. It is not helpful to have rules that no one looks at or follows, or that are out of date and inconsistent with the law. What changes are required? The new law means that organisations must review and update their constitution as well, because there is a number of changes regarding financial reporting, management or governance, privacy, dispute resolution, the rules, becoming incorporated, and membership of incorporated associations. Financial reporting. The new Act introduces a three-tiered system of financial reporting and accountability requirements based upon the organisation's revenue. Access Plus WA Deaf is a Tier 3 organisation with a revenue of over $1 million. So, we must prepare financial reports in accordance with Australian accounting standards that give a true and fair view of the financial position of the association. The financial reports must be reviewed by a professional accounting body holding a public practicing certificate. Management or governance. The new Act details the obligations of committee members, which exist under common law. The duties are similar to the duties that directors owe to corporations under the Corporations Act, and include the duty to exercise care, skill and diligence in the performance of their duties, For a committee member, this means being prepared for meetings, understanding in broad terms the organisation's financial position, following up on action items, and keeping up to date with the organisation's activities. The duty of good faith and proper purpose requiring an officer to exercise his or her powers and discharge his or her duties in good faith in the interests of the organisation and for a proper purpose. Discharging this duty will require the committee member to use his or her powers only for the benefit of the organisation and not to secure a private advantage. The duty not to misuse their position or information. Discharging this duty will require the committee member not to improperly use information or use his or her position for personal profit or for the profit of the third party. The duties will also be owed by persons who influence the management of the organisation, but who do not hold a committee position. This would include senior employees or past committee members who are actively involved in the organisation and influence the decisions of the committee. The new Act also introduces fines of up to $10,000 for committee members who breach their duties. The new Act also provides that the following persons will be disqualified from being a committee member of an association. A person convicted on an offence in connection with the promotion, formation or management of a body corporate. A person convicted on an offence involving fraud or dishonesty, punishable on conviction by 3 months or more imprisonment, and an undischarged bankrupt whose affairs are under insolvency laws. Privacy. The new Act will now provide a flexible approach as to what contact information a member must provide to his or her association, and limits what can be done with the information. Members may now provide a post office box or email address for contact instead of a residential address, and a person must not use or disclose information in the register except for a purpose that is directly connected with the affairs or the association, or a purpose that is related to the administration of the Act. Dispute resolution. The old Act did not prescribe a court for the hearing of disputes, and by default, most disputes are currently heard by the Supreme Court. The new Act provides that each association must include an internal dispute resolution process in its rules, and provides that any unresolved dispute can be heard by the State Administration Tribunal, SAT. The new Act also introduces a process for the Commissioner to apply to the SAT when the appointment of a statutory manager to administer the affairs of an association when an association is not functioning effectively. When must we make the changes to the Constitution? As of 1st of July 2019, relevant clauses of the new model rules contained in the Associations Incorporation Regulations 2016 automatically apply where a constitution is non-compliant or silent under the new Act. For example, the old constitution did not clearly state the financial year for Access Plus WA Deaf, so on the 1st of July 2019, the organisation's financial year will be the 1st of July to the 30th of June, as per the model rules. The 2019 AGM is the opportunity for the members to approve these changes and adopt a new constitution. What is the legal process for making changes to the Constitution? The legal process requires the members of an incorporated association to pass a special resolution at a general meeting, resolving to accept any changes to the Constitution of the incorporated association. A special resolution can only be passed at a general meeting of members. This can either be the annual general meeting, AGM, or a special general meeting. The special resolution will only be passed if at least 75% of those members eligible vote in favour. This includes members who are not actually present at the meeting themselves, but whose proxies cast votes on their behalf. How to get more information before the AGM. If you would like to discuss any of the changes outlined in this video, or want more information before the AGM on the 29th of October 2019, you can contact the CEO of Access Plus WA Deaf, David Gibson. To arrange a meeting time with David, please send an email to enquiry@accessplus.org.au or come into our office at 34 Dodd Street, Wembley.